So we left off in section 7, but just before we go back down to section 7, important to review just the very first piece here, right? This agreement is that, the broker agrees to provide brokerage services to the buyer, period. And then maybe you'll earn a commission or compensation as set forth in the contract, but it depends on how you fill out the commission section, or any other sections you may write it into, like additional provisions or whatever. And so, this agreement, you have duties as the broker, regardless of whether you're going to get paid. Whether you want to get paid or not is up to you and how you draft this contract, right? And so, this is particularly applicable to what's going on in our market right now, because you're seeing a lot of builders, for instance, who are saying, oh, we're not paying any co-op brokers, period, or we're going to pay 1% or 1.5% or 2% or whatever. There's just, as an industry, generalization, there's downward pressure on commissions. And honestly, like right now, are you really going to be the person who holds up a deal? If you're representing a buyer and, whether you have an exclusive right to buy that says buyer's obligated to pay or not, right? If they're offering a 1% commission to you and you have an opportunity to lock it down for your buyer otherwise, are you going to lock it down, or are you going to say, hey, buyer, we can pursue this one, but I'm going to have to pursue you for the other 2%? I mean, there's nothing wrong with that from a legal perspective, but it's a difficult, moral dilemma, right? And it's not right or wrong, right? We have legally acceptable and legally not acceptable, but aside from that, like, there's no right or wrong. It's up to you to decide what you do to enforce it. And so, having said all that, we get to section 7, and section 7 is where we deal with the compensation. And so, 7.3 is really where we determine who will pay, who's obligated to pay, who's not. But before we get there, so section 7 says, in consideration of those services that you are going to perform as the broker, you'll be paid as set forth in the section 7, with no discount or allowance for any efforts made by the buyer or any other person. And so if the buyer, goes and they, start looking on Zillow or Call Property or homes.com or whatever, right? And they find the house and they're like, hey, can we set up a showing? And then they're like, hey, Angela, you didn't even find this house for us. We found it ourselves. Well, that's okay. There's no discount or allowance made for any efforts by the buyer. I certainly advise them. I typically set them all up on an automated search, but I still advise them to go do their own searching too, right? If they find a for sale by owner, or if they're, they find a home that's slightly outside of the parameters that I've set up for their auto search or whatever it is, right? I still want them to do some of their own searching and have some skin in the game too. So totally okay for them to do that. That doesn't mean that we have to discount our commission for that. So no discount or allowance made for any efforts by the buyer or anyone else. Okay. Unless otherwise agreed to in writing, you're also entitled to receive additional compensation or bonuses that are paid by the listing brokerage firm or seller. Now, if you do receive some kind of bonus or incentive or whatever, then you will inform the buyer of whatever the fee is that gets paid. And they had to add that part into our agreement several years ago, because what was happening was there was a builder, particularly out of the Loveland area, I think, and what they were doing was they were saying, hey, brokers will pay you 3%. And then there was this undisclosed like $20,000 worth of bonus or commission dollars that were getting paid to the broker, right? And so at the closing table, broker's getting, let's say it was a $200,000 house back then, broker walks away with $6,000 for the commission, in conjunction with the sale. And then they also walk away with $20,000 in bonus money from the builder, right? And so if you're a home buyer, what are you thinking when you see that? Like, oh, my broker agreed to 3%, and here they are walking away with, 10%. What do you think the home buyers were feeling?
You probably thought that you were steering them towards that house for that extra commission.
Yeah, so not only did they feel like you're steering me towards that because you have an interest in lining your own pocket, right? But they also went, hey, I could have bought that house for $20,000 less if I wouldn't have had a broker involved in the deal. And so I paid way more than I should have because of this undisclosed, $20,000 bonus that was getting paid to the broker. Okay. So you can certainly earn bonuses above and beyond whatever the compensation amount is in your listing agreement, unless you agree somewhere else in that contract that you can't. You can certainly accept those, but it has to be disclosed. Okay, everything needs to be above board. We can't be taking money under the table or anything like that. It all needs to be above board. Okay, so you have the right to accept additional compensation. You got to notify your client. And you'll supply a copy to the buyer upon the written request of the buyer. Okay, even if they don't request a written copy or anything, you still have to disclose it. Okay, there's no way around that. So section 7.1 talks about what type of compensation you will receive. And so most of us are familiar with 7.1.1, which we'll come back to, but it doesn't have to be 7.1.1. You could certainly charge an hourly fee. There is nothing wrong with that. Now there is some complexity in doing that. How do you, clock your hours? Who's watching that? Is there, some type of system that allows the buyer to review that? So that can get a little bit tricky, and it's not really something that we typically see very often, but it is legally acceptable to charge an hourly fee. Same thing with a retainer fee. So a retainer fee would be like, hey, you're going to pay me a non-refundable fee of, $5,000 or 2,500 or 10,000 or whatever your number is upon the execution of this listing contract. And then either it will or will not be credited against any other fees that get payable to the brokerage. So you can also multi-select here. And so you could say, hey, we're going to have a success fee equal to a certain percentage of the purchase price. But if you want me to be your broker, right, then you will pay me a non-refundable retainer fee up front as well, right? And maybe, for instance, if you're going to send out postcards to a neighborhood that says, hey, I have a buyer who's interested in a home in this, particular neighborhood, well, you can actually charge the buyer for that. And the best way to do that would be to check this box in 7.1.3 that says, hey, I'm going to charge you a retainer fee of $600, and really that's going to cover the cost of me sending out all these postcards. Because then if you decide not to buy something, I'm not out my $600 that I spent on mailing postcards out. Okay. And then yeah, go ahead.
I've seen retainer fees for commercial properties that were unbelievable, but they have them.
Yep.
Yeah. So I see that a lot with commercial properties.
Yeah, so commercial properties, there's a lot of out of the box stuff with respect to commercial properties. And in some cases, they actually will skip all of these sections with respect to the type of compensation, and then they'll go down into additional provisions, or they'll have some, addendum that they add to the contract. And so in some cases, you'll have commissions that get paid out in a weird structure, like you get 25% of the commission at closing, you get 25% of the commission at once we start doing tenant finish, you get 25% of the commission once the tenant moves in, and you get 25% of the commission after they've been there for a year and made all of their lease payments, right? So you get some really bizarre stuff in commercial, but certainly, again, a retainer fee could work in a commercial setting as well. Doesn't have to be commercial. It certainly could be in a residential setting. You just need to know, what your options are. And most of us will not venture outside of 7.1.1 for the most part, but you do have options available. And then if you do charge that retainer fee, either it will or it won't be credited towards some other amount of commission that you may earn, if you do in fact earn a commission on the closing, whether it's a commercial lease or commercial purchase or residential purchase or whatever, right? Is it going to be credited to that other amount of commission, or is this in addition to some other form of commission that you've set forth in the contract? Okay. 7.1.4 is some other form of compensation. other than a success fee, hourly fee, or retainer fee. And so what some people will do is they'll say, hey, this amount, right? But if it's over $1 million, then it will be reduced from 2.8 to 2.5 or 3 to 2.5 or whatever your numbers are, right? And so you can do that a couple different ways. You can come down here and do that in 7.1.4. You can go down to additional provisions and put something in there. It's really up to you. But you're welcome to write in something else in here. Keep in mind, anytime you write something into the contract, it's not something that's been approved by the real estate commission. And so you need to be careful about how you're structuring that and make sure that it's very clear. And that's the problem that a lot of brokers run into, is that it's just not clear what the actual agreement is when you start adding all of these variables on, like, okay, if this applies, then the commission will be this. If this applies, then it will be this, right? And they just don't think about, okay, well, what happens if we have something other than this situation or this situation? Now we have this situation. Well, if you didn't plan for that, then you may have a situation where it's not clear whether you've even earned a commission under your contract or not. So you need to be careful about what you're putting in here. But if it's clear, it's clear. And one of the important pieces is you need to check the box for whichever respective section you're going to do. And so, a lot of times we'll see these come across and it'll say, a fee equal to 3% or 2.8 or 2.5 or whatever your number is. But then they won't check this box. Well, what does it mean if you don't check a box in the contract?
Why?
Yeah, it doesn't apply. Right. And so then you have a section that effectively looks like it doesn't apply, but then you've written some provisions in here. Well, which is it? Does it apply or does it not? I don't know. So to make it crystal clear, right, if compliance sees that you've got an exclusive right to buy and you don't have a box checked in 7.1, whether it's 7.1.1, 0.2, 0.3, or 0.4, right, they're going to send it back to you. Okay, now this has nothing to do, section 7.1 has nothing to do with who pays your commission. That's in 7.3 that we'll talk about here in a minute. So all this does, it says, this is what I've earned, and this is the applicable section under this contract, right? And so most of us will check the box in 7.1.1, and then we'll have a certain percentage of the purchase price. And just an important side note, guys, first of all, there is no standard commission, okay? And be careful about, we can talk about it amongst those in our office. We can talk about commissions and everything else. But once we get outside of our office, we're starting to tread into Sherman Antitrust Act stuff. And that's a federal law. So if you want a federal lawsuit on your hands, then go talk freely about commissions on a public forum or with a broker outside of your office or something else, right? It's just not worth it. And so it's almost a daily occurrence that you see on a lot of the national like Facebook pages and stuff like that. Like, oh, can you guys believe this? They're only paying 1.5% commission. Well, there's nothing wrong with that because there's no standard commission. Now, you might not like the fact that they're only paying 1.5%. And so when we get down to section 7.3, we'll figure out, okay, if you really want to push and show your value and stick to it, then there's a way to do that. But trashing someone else for paying less than what you might think, is the standard commission, you're wading into federal antitrust stuff. Okay. So you can either do it as a percentage or you can do it as a flat fee. If you want to do a flat fee, you could write that number here. You could certainly write, 2.5% or 3% or whatever, but not less than a specific flat fee, right? And then that way, what you're effectively saying is, hey, I'm going to earn this amount, but if it turns out that they're only paying a certain percentage, then I will take that as long as it's not less than this amount here, right? So there's a little bit of variability in that, but it's still clear what it means. Okay, so any questions on that piece, 7.1.1 or any of these
Jesse, I've
other?
got some.
Yeah, okay.
So I'm just curious, do you, if a commission is, if a lesser commission than what's, okay. You know where I'm going with this.
Yeah, I know where you're going. And this is a problem, right? And I'm not saying for this class, but this is this is a problem on the national, public facing pages. And so to answer your question, if there's a commission that is being paid to me or offered to me that is less than what I have agreed to as my success fee, right? Then do I pursue the buyer for it? No, not typically, but I want you to hold that thought until we get to 7.3. Okay.
Okay.
So do you have another thought, or is it pretty closely related to that?
It's all related to
Okay,
it because it's,
so-
I mean, as we all know in this market. Anyway.
Yes. Okay. So let's hold that thought till we get down to 7.3. Okay. 7.1.1.2, you could have an adjusted amount, and you can either spell it out here by checking the other box, or just check the box and say, hey, go see additional provisions. If there's something that really is a success fee, but maybe it has those variables, right? Then this is the box that you would check, where, you might, again, another agreement that you might have is like, hey, my success fee will be, let's just say 3%. But if you list your house with me, then I will, do 2%. I'll effectively rebate you back 1% of the commission. Now, if you're going to do rebates, you got to, again, it has to be disclosed on the settlement statement. You can't give them an envelope full of cash at closing or anything like that. It all has to be on the settlement statements. And there's really a better way to do that, which is to effectively just say, hey, seller, rather than pay me let's say they're offering a 2.8% co-op, right? So rather than pay me 2.8%, you are only going to pay me 2%. And then you're going to credit the buyer closing costs in the amount of whatever 0.8% is to offset that, agreement that you have. Whoops. To offset whatever that agreement is. Now, where you got to be careful is if your buyer is already asking for closing costs, first of all, it's probably not in this market. But in a normal market, let's say where closing costs may still be a thing, if your buyer is already maxed out as far as closing costs go, it may not be possible for you to ask the seller to contribute additional dollars to the buyer's closing costs in conjunction with your, trying to finagle the commission amounts. And so where that gets a little bit weird is you've technically earned let's say they're offering 2.8% and you want to rebate 0.8% to the buyer because of some agreement that you have, right? You've technically earned a 2.8% commission. And so really then the market center should be taking cap and royalty as if you had earned that full 2.8, even though you've agreed to rebate a portion of that commission back to your buyer. That's not a cost that the market center should be bearing. And in most cases, they won't, depending on how you structure it. If you structure it though as, hey, I'm only earning 2%, and then seller is giving that 0.8% back to the buyer, then you've only earned 2%, right? Then market center should only take cap and royalty based on the 2%. You should only be taxed on the 2%, right? So you guys need to be aware of that, but it doesn't work when you already have a buyer who is tapped out as far as the amount of seller concessions that can be applied to their loan. Because, if the lender can only use, let's say $5,000 worth of closing costs, and by the time you tack on this 0.8, right, it ends up being 9,000. Well, that $4,000 is effectively just going to go back in the seller's pocket. Now you can have some other agreements where maybe if it's agreed to in writing that $4,000 may come off of the purchase price or, something like that. And there's different types of loans. Some loans can use infinite closing costs. For instance, like a VA loan, they can use closing costs to pay off HOA dues like into perpetuity. And so I closed a deal with my cousin, and it was a VA loan, and it was a builder, and this builder was offering like $12,000 in concessions or something for using their preferred lender. And so my cousin had his HOA dues paid off for, I don't even remember how long it was. It was like the next 12 years worth of HOA dues paid off with this 12 grand, but not all loan types can use that money to pay, closing costs and all that other stuff. So just be aware of that. It's a thing. Okay. The success fee is earned by the brokerage firm upon the purchase of the property. If you remember last week, we defined the purchase as the creation of an obligation to convey an interest in real property, or in other words, the execution of the contract by all parties. And so what this says is that your success fee is earned when the contract is signed. However, it is payable upon the closing of the transaction. Now, there's some caveats to that. If the transaction fails to close because of a seller's default with no fault on the part of the buyer, then the success fee is waived. So even though you've earned it, it's not going to be payable at all if it's due to seller default. Now, if the transaction fails to close as a result of the buyer defaulting in whole or in part, then the success fee is not going to be waived, and it would be payable either upon the buyer's default or not later than the date that the transaction was supposed to have closed on. Okay. So know that there's a difference between when the commission is earned and when it is paid. And it kind of depends on whether, if it doesn't close, is that the fault of the seller? Is it the fault of the buyer? And that being said, the buyer terminating within the rights of their contract is not a failure to close as a result of the buyer's default. But that doesn't mean you've earned your commission and you can stick it to the buyer if they had a right to terminate based on the contract and they exercise that right. Okay. So any questions on 7.1 before we go to 7.2?
Real quick, how are you explaining this section to a buyer in order not to scare them off by it?
So 7.3 is really the section that is scary to buyers. 7.1 just says, hey, how much are you earning on this deal? Right? And which section is going to be applicable here? Are you earning a success fee that is a percentage of the purchase price? Right? Again, this has nothing to do with who's paying it. This is just how much are you earning, whether it's paid by the buyer, seller, somebody else, right? And so, again, I want you to hold that thought until we get to 7.3, because I'll tell you how I explain it in conjunction with this section. And that's maybe, I think, a little bit more what you're getting at, is having a buyer check a box that says the buyer is obligated to pay is scary to the buyer. And so that's where a lot of brokers have this fear of no, I don't want to check that box because I don't know how to explain it. And if you do know how to explain it, it's really not that scary. And we can even talk about some additional verbiage we can put in there to make it less scary. So hold that thought too, okay? Okay, so 7.2 talks about the brokerage firm's lease fee. In most cases, you're not going to be leasing property. If you are, then section 7.2 is what you would fill out as far as the commission or the compensation with respect to a lease of the property. And this is, in many cases, this is commercial, right? But certainly applicable for a residential type rental situation if you're leasing the property. I will say real quick during this section, there is a difference between leasing and property management, right? Leasing is just you're agreeing to help a landlord find a tenant, or you're helping a tenant locate a rental property. Property management is I'm agreeing that I am going to take on some duties after leasing the property, or helping the tenant lease the property. I'm going to have some ongoing duties associated with maintenance of the property, collecting security deposits and holding security deposits, collecting rents, scheduling contractors, right? That's property management. But leasing is simply just helping a landlord lease a property or helping a tenant find a rental, okay? And leasing is much less risky, okay? However, property management is one of the biggest issues that realtors are facing right now with respect to the real estate commission, because most people aren't doing it correctly. Most people don't have the proper trust account set up to hold security deposits. Most of them don't understand how to do, three-way reconciliations, all those ledgers, journal entries, all of those things. And so most brokers who are doing property management, if they actually got audited and they realized hey, you're doing property management, we need to see your books, then they're going to get hosed. And they're taking licenses away from people who are doing that if they're not doing it right. Because one of the biggest concerns for the real estate commission is, are you properly accounting for other people's money, or are you not? And if you're not, then they're just absolutely going to hammer you. Okay. So be careful about it. Leasing is very easy to do. Not to say that there's no liability there, but much less liability than an ongoing agreement where you need to have trust accounts set up. You need to understand the accounting behind all of it, right? Much less liability when you're simply leasing as opposed to property management. This form in and of itself, even though this is the exclusive right to buy, right? And there's a whole separate form for exclusive right to lease or exclusive tenant contract. None of those are really sufficient to be a property management agreement in and of themselves. Now, you could certainly write an addendum to, an exclusive right to lease, right? Or you could, jam a bunch of stuff in additional provisions, but typically you need a property management agreement if you're going to manage property, which most people on this call are not authorized to do property management. There are some brokers at some of our offices who are, but for the most part, we do not authorize brokers to do property management. Leasing is a different story, okay? So if you're going to do leasing, then, you can either charge some flat rate, you can do some dollars per square foot, whatever, right? Or some other agreement where maybe it's a portion of the total lease, or, however you want to do it. There's much more fluidity with respect to what this agreement might look like when you're charging a commission in conjunction with leasing a property. Now, I will say, in helping a tenant to locate a rental, in many cases, landlords aren't going to pay you anything. There are some property management companies that will pay you, if you refer them per door or whatever, they might give you like $200 or $250 or whatever, but it's not an extremely profitable thing, but maybe an opportunity to earn a couple bucks on the side. Okay. So again, there's a difference between when that commission is earned and when it's payable with regards to a lease. So again, similar provisions, not going to hit it hard here, but if you are going to lease a property, that's what would apply. Okay. So let's talk about 7.3, and this is where really most of the people have questions. And I think the reason that we see 7.1 come through with none of these boxes checked is because brokers think that somehow 7.3 is part of 7.1. It's a different subsection. And so what 7.3 deals with is who is going to pay the brokerage firm's success fee. And that success fee, you'll see, is here, right? It's defined up here. This is your success fee, okay? So if we check the box in 7.3.1, it says the buyer is obligated to pay. Now, that doesn't say that the buyer will pay, because that's 7.3.2. So if you're in a situation where the seller, let's say you have a FSBO, right? And the FSBO says, no, I am not going to pay anything, right? Well, how are you going to work that, right? If in section 1, it says the agreement is you are going to provide brokerage services, period, right? You may or may not get compensated based on how you fill out the rest of this form. And so if you've agreed to perform brokerage services, but the seller is not paying a commission, let's say it's a FSBO, or let's say it's a builder, right, who has decided that they're not going to pay co-op commissions, and you've got this box checked that says the buyer is not obligated to pay, okay? Let's look at this first sentence here. First sentence says, the broker is authorized to obtain payment of your success fee from the listing brokerage firm or the seller, period. How does that differ from 7.3.1? What's the difference between 7.3.1 and 7.3.3?
Well,
Yeah, go ahead, Harry.
Well, buyer's obligated to pay that, whereas in 7.3, if in fact the seller or a FSBO isn't going to pay, then you're out, right?
Yeah,
You're doing it for nothing.
Yeah, so in 7.3.3, you are only authorized to obtain your payment from the listing brokerage firm or the seller.
Right.
And if they don't pay, you don't have a contract with them to force them to pay. So you have no protection in the form of the payment. But what does section 1 of this contract say that you will still do?
Brokerage services.
You're going to do it all.
You're going to provide brokerage services. So if you're checking this box in your contract, there's a possibility that you could work for free. Okay. And in many cases, you know, those are the riskier deals, because a builder's contract is very much geared towards the builder, not towards the buyer, like the Colorado contract is, right? It's very much geared towards the seller or the builder. And so buyers run into many more obstacles in a builder's transaction. And then when you have a FSBO, right, where the for sale by owner is not represented by a broker, they, again, a very, you know, much more common to have complaints in those type of deals because the FSBO feels like they got taken advantage of and whatever. Of course they did. They didn't have a broker, right? So, but that doesn't mean that they can't file a complaint against you, right? Whether you're in the right or in the wrong, it doesn't matter. So, you know, the liability on those deals is certainly higher, and you're going to set yourself up to work potentially for free. So the difference is, if you read the very first sentence here in 7.3.1, right, as opposed to this one where it says you are only authorized to obtain your payment from the listing brokerage firm or seller, what this says is that you're not only authorized to collect your payment from them, but you're also instructed to go request your payment of your success fee from the listing brokerage firm or the seller. And so what checking this box does is it allows you to write your commissions into the contract to buy and sell between the buyer and the seller. Okay. If you have this box checked, you have no authority to request payment of your brokerage firm success fee from the listing brokerage firm or the seller. You are only authorized to collect whatever commission is being paid. Okay. Now, if you have this box checked, you can go straight into additional provisions in your contract. Say, you know, seller agrees to pay a 2.8 or 3% or 4% or whatever your number is, whatever your success fee. Now, it can't be more than what you've got listed up here as your success fee. Okay. So whatever your success fee is, you can then go write that directly into additional provisions. And that's a misconception that a lot of people have. They say, oh no, you can't address commissions in the contract. You very much can under the right circumstances. And the right circumstances are, I've got this box checked in 7.3.1. Okay. And so when you get the question, and we'll come back to 7.3.2, but when you get the question of like, I'm obligated to pay, right? Two things. One is it doesn't say that you will pay. Right? I didn't check this box saying buyer, you will pay, right? And two, it says if they're not paying me the success fee that you buyer and I have agreed upon right here, then I have the right to ask them to pay me whatever that amount is. If they say no, then I can come after you buyer for that. However, that's up to you. Okay. Now,
Jesse, I have a
yep.
question.
Yeah.
So in a contract to buy and sell, let's say you're working with the buyer and it's listed at 2.6 and you guys had put 2.8.
Mm-hmm.
In that contract to buy and sell, you can put down an additional provisions commission to buyer's agent is 2.8.
Correct. Yep. Now, again, the question, right, that Angela was posing is, are you actually going to go after your buyer for that? Well, I'm not going to, in most cases, I'm not going to go after my buyer for that, right? Now, do I request it in the contract itself, though? That's a different story, right? So I may or I may not. Now, if it's 2.6 versus 2.8, I'm probably not going to do it. Because the other thing is, particularly in this market, if the seller has to pay more commission on your deal than someone else's deal, it makes your offer less palatable to the seller because they have to pay you more, right? So this section does not say that you are obligated to pursue the buyer. It simply says, hey, I'm not working for free, right? I am instructed to go request payment that you and I agreed to, right? You agreed that this is what I should be paid as part of our deal, right? I'm not asking you to pay. I'm just asking you that, hey, rather than put myself in a position where I'm forced to provide brokerage services to you and take on liability on your behalf and be an advocate for you and get the best deal for you and have to do that for free, I'm protecting myself as well. And so if we get to that point and we request it in the contract and the seller says, nope, I'm not willing to pay it, period, right? Even after I've requested it, then the decision is up to the buyer. Do I want to pursue this property and have youth broker pursue me for whatever the success fee is, or do I not? And if they don't, that's great. That's their choice. And if they do, that's great. That's their choice too. But your obligation is to provide brokerage services regardless. And you can't simply send them a list of properties that only pay, 2.8% or higher, right? If they want to see a property that's at 1%, you have to show it to them. You can't say, no, I'm not going to show you a property because the commission is too low, right? What you can do is you can check this box, and that effectively puts them in the driver's seat as to, hey, okay, it's only 1% and I really don't want to pay the extra 2% or 1.8 or whatever your number is. And so therefore I'm choosing not to go see that property. Okay. The buyer, again, the buyer has an obligation to pay that portion of the success fee, which is not paid, but the broker is not obligated to pursue the buyer for any deficiency. And so, what I have seen in the past is, some people come up here, right, and they'll check the box in 7.3.1, and then they'll go down to additional provisions and they'll say, well, I won't pursue you for the difference as long as it's over 2%. That's completely unnecessary, because you could simply come back up here and say, hey, I'm going to earn a fee equal to 2% of the property, right? Or 2% of the purchase price. And I have the ability to receive additional compensation if they're offering 2.8 or 3%, right? So if there's a number in your mind that's like, I'm willing to do less than what you believe to be a standard commission, which doesn't exist, Angela, right? If there's a number that you're like, I will do it as long as it's not less than this amount, you simply come up here, put that number in here. Let's just say it's 2%, right? Put your 2% in there. If they're offering 2.5 or 2.8 or 3% or 10%, you can take that. That's fine. You need to disclose it in writing to your buyer, but they don't have a choice. As long as it gets disclosed, that's fine, right? And then you come down here and you check the box that says, buyer, you are obligated to pay. I'm not working for less than 2%. If your number is 1%, then come up here and say 1% here, right? You still have, you're still entitled to receive additional compensation if it's being offered, right? And you're only going to pursue the buyer for your 1% deficient, or for the deficiency between, anything less than 1% and whatever's being offered. Does that make sense?
So Jesse, I think you inadvertently went to the regular percentage, like the 3% when you're pointing up, but you're saying that if you fill in 3% up there on the top 7.1, then your minimum, right? You're not less than, so it should be 1% in there, or no? Or you're saying just your
it depends on what your absolute minimum percentage that you're willing to work for is.
right.
If you say, hey, listen, if you find a FSBO or let's say a new build, or what, it could be a regular co-op deal, right? Where let's forget about FSBO and new build. Let's say it's a regular co-op deal, but the co-op commission offered on that is a flat fee of $1,000, and it's a $500,000 house, right? And your conversation with the client is, I tell you what, certainly I would prefer to make 3%, right? Let's use a very common number, even though it's not a standard number. Let's say 3%, right? You would certainly prefer to earn 3%, and that's a very common thing, right? However, buyer, if you find a home and they're only offering 1% or less than 1%, right? I'll still work for you so long as I am entitled to receive at least 1%. Then you could come up here and you could write in 1% in 7.1.1.1, knowing that if they find a house that's offering 2.5%, you can still take 2.5%, right? But you're not putting yourself in jeopardy from the perspective of working for less than your 1% that you've put here, because you have an opportunity to ask the seller to pay whatever your minimum success fee is equal to up here. Okay. And if they pay more, if they're offering more right off the bat, you're entitled to take it.
Okay.
Does that make sense to everybody?
So Jesse, say for instance, you put in 7.1.1.1, a fee equal to 2.8%, which is a common percentage that we see.
Mhm.
If more is being paid, by putting that in there, are you not able to get that amount?
If more is being offered, no, you
Correct.
are. If you put 2.8 here and you do a co-op deal that's 3%, you're
Right.
entitled to receive that additional compensation, that extra 0.2, right? You're entitled to receive that. Now, it just needs to be disclosed to your buyer in writing, but as long as that's all above board, that's okay, right? And if they sign this, they don't get a say in whether you receive that extra 2.2% or not, right? You just get it. Okay. Say, and so then the question is, well, why don't I write 2.8% in here, but then add a provision that says yes, I have 2.8% and 7.1.1. And if they're offering less than that, I have a right to ask for that amount. But in no case am I going to pursue you for anything less than 1.5%, let's say. Well, it's unnecessary. You don't need that clause. You would simply put 1.5% here, right? Because then you're not pursuing them for the extra 1.5, anything for less than 1.5%, right? But then the brokers are like, well, but what if I want to ask them for 2.8, right? But I'm only going to pursue my buyer for 1.5, anything less than 1.5. Well, if you're only going to pursue them for anything less than 1.5, then you shouldn't be asking for anything more than whatever your minimum is that you're agreeing to with your client. Does that make sense?
It does, but but what if you're like in your mind, your minimum that you'll accept on any deal, like, because you know your value and you know your worth is 2.8%. So you put 2.8% in your ERTB template.
Yep.
So then you go in under 7.3.1, you check the box, and then you have the conversation with your buyer.
Yep.
Like, okay, I'm going to show you these new builds. This particular builder is paying 2%. So the differential will have to come from you, the 0.8%.
Yep.
So that's the way that conversation would go.
Yeah, correct. Now, again, you got to decide, am I actually going to ever pursue my client for that or am I not?
Right.
And certainly this is a way to protect yourself with what's going on in our industry right now. Right. It is, we have to rely on the exclusive right to buy instead of taking whatever the co-op is that's offered. Because while that may have been a very, comfortable 2.8 or 3% in the past, it's not anymore. Right? That wall is starting to come down. And so in order to protect your value, we have to rely more heavily on our exclusive right to buy. And by checking this box, you're offering yourself no protection, right? And so, again, how much protection do you want to afford yourself is up to you. There's no right or wrong, right? The real estate commission doesn't care whether you earn a dime or whether you do it for free, right? What they're concerned about with is, are you doing your contractual brokerage duties to your client? I don't care whether you get paid. Okay. So it's kind of an unfortunate spot that our industry is in, but if you want to protect yourself, this is how you do it. Right. And the difference is, here, I'm only authorized to take whatever is being offered. Here, I am instructed to go get my success fee from the listing brokerage firm or the seller. Right. And that way I have authorization from my buyer to go request it as part of our contract, but it can't be more than whatever is listed up here in your success fee. So I can't put 1.5% here and then go ask for 2.8% in the contract. Okay.
So, Jesse, a lot of people put 2.5 plus, right? So it gives them that flexibility. I know.
But you don't need it.
I know, but they do.
I know, but you don't need it, right? If I
Okay.
put 2.5% here, I'm still entitled to receive additional compensation bonuses or incentives that are paid by the listing brokerage firm of the seller, I don't
Okay.
need to put the plus because I have my 2.5% here, right? And then at a minimum, I can ask for up to 2.5% if they're offering less than that. So adding the plus does not add anything. It's already spelled out in our our agreement. And what
Okay.
and it's not only that, I mean, it's not even that it's okay to do that. You shouldn't do that, because effectively you're creating confusion on behalf of the buyer, right? Where you put 2.5% plus here. Well, so then does that mean if I check the box in 7.3.1 that I can go ask them for 12% commission?
Yeah. Okay.
That's more than 2.5%, right? So
Right.
it's actually wrong. It's not even that it's okay. It's wrong to put 2.5% plus. You don't need the plus. It's already spelled out. And because this section refers back up to that section, right? Then I have a specific number that I can ask for, or percentage that I can ask for. That makes sense?
So Jesse,
Okay,
just
so
to
one more
clarify, oh,
Mhm.
sorry, go ahead, Terry.
No, go ahead.
No, you're fine.
So Jesse,
Yeah.
my sort of thing on this is 7.3.1 allows you to negotiate with your buyer. 7.3.3 doesn't. Does that make
Correct.
that? Okay.
Yeah, and so a lot of brokers, what they'll do is they will put a provision in additional provisions, right? That effectively says something like, in the event that the seller wants to see a for sale by owner and the FSBO is not agreeing to pay a commission, then the broker and the buyer have the right to negotiate, a negotiated commission prior to pursuing that contract, right? And so what that ends up looking like is, so Liz, I'll have you unmute yourself because you've been on enough times to know. So Liz is my buyer client, and I'm the buyer's agent, right? And I have that agreement in my contract that, hey, if Liz wants to go see a FSBO and they're not paying a commission, her and I have this agreement to negotiate a commission, right? And so what I do is I'll say, okay, hey Liz, you see this FSBO, they're not offering any co-op commission. And so we have this obligation in our contract to negotiate a commission. And so, even though my success fee was 2.8%, right? And I checked the box that said the buyer's not obligated to pay, right? Even though my success fee said 2.8%, I'm willing to still help you get the house and provide you with brokerage services. But I need, you're going to have to bring 2%. So does that work for you?
Yes.
Say no.
Okay, no. Actually, nice.
Okay. So Liz says, hey, that's all fine and good, but no, I'm really not willing to pay 2%. You have an obligation to perform your brokerage services to me anyway. And no, I don't want to pay the 2%. And I'm like, okay, fine, Liz. I understand where you're coming from. I got to get paid too, but I'll do it for you for a minimum of 1.5%. That's got to come from you. Is that okay?
No.
Okay, Liz, how about 1%? I got to make something on this deal.
How do you want me to answer?
Just keep saying no.
No.
This is outside of Liz's wheelhouse because she's too nice of a person to do this. But have Liz and I negotiated at this point?
Yes.
Yeah, we've negotiated. And where have we gotten with respect to our commission? Nowhere. And what does section 1 say that I am still obligated to do? I'm still obligated to perform brokerage services. And if I've checked this box that says buyer, you're not obligated to pay, I don't care whether you have some agreement in additional provisions that says you agree to negotiate, some other compensation, right? It's completely unnecessary to address it. You can do it all within the confines of section 7.1, 7.2, 7.3, right? You don't need to address it in additional provisions. This is how you protect yourself, 7.3.1, where the buyer is obligated to pay, and you don't have to put 3% or 2.8 or 2.5 or whatever, right? You can put 1.5% if that's your absolute minimum. You can put 2.25%. I don't care. You could put 4%, but that is how you protect yourself. Is you come down here, you check this box that says buyer, you are obligated to pay. And if you're only worth 1%, right, and that's all you think you can negotiate with your buyer as far as what they should be on the hook for, then put 1% and receive whatever additional compensation or bonus you can get. But effectively by doing that, you're saying, buyer, I won't pursue you for anything more than 1%.
Jesse, have you ever had a transaction where the buyer just flat out didn't want to sign this contract at all? And I'm just curious.
Yeah. So usually when that comes up is like, if I'm the listing broker, right, and I have an unrepresented buyer come through and they go, hey, we want to purchase this property. And it's like, okay, there's two ways that we can do this. We can either sign an exclusive right to buy, whereby I have brokerage duties in conjunction with our exclusive right to buy, or we can do this with a broker disclosure to buyer. And if we do a broker disclosure to buyer, then either I can only treat you as a transaction broker, I cannot treat you as a buyer's agent, because that option doesn't exist in a broker disclosure to buyer, right? I can only be a transaction broker for you, or because of my agency relationship with the seller, right, then I have to treat you as a customer. And so if they're not willing to sign, my preference would be, if you're in an agency capacity with the seller, right, then treat the buyer as a customer. I don't want to take on brokerage duties for someone who is not willing to sign an agreement with me whereby I have some form of, compensation spelled out, because compensation is not addressed in a brokerage disclosure to buyer, right? The brokerage disclosure to buyer simply says, hey, by default, I'm a transaction broker for you. Or if I have an agency relationship with the seller, I have to treat you as a customer if you're not going to sign an exclusive right to buy. Okay. So yes, that has happened. The other thing, I've had a couple deals where, I really didn't fully understand the complexities of 7.1, 7.1 and 7.3. And so I checked a box where, it said the buyer is not obligated to pay. And so I used to be a deputy at the Larimer County Jail, and one of my coworkers, she was getting a divorce from her now ex, and she wanted to effectively buy him out of the property, right? And so they were like, okay, we need someone to help us with this, right? I'm like, okay, yeah, that's fine. And so I'm like, yeah, my coworker, who was the one buying out her ex-husband, I'm like, well, I don't know him. I've never met him. I obviously know her. So I was like, I'll be a buyer's agent for you, right? And I put my success fee as 3% in the contract. And then I check the box that says, no, buyer, you're not obligated to pay. Okay. And so I draft up all the contracts. I do all the addenda and disclosures and all this other crap. We get to like 3 days before closing, and title sends out the estimated settlement statements, and it shows a 3% commission being paid from the seller to me as the only broker in the deal, right? I wasn't going to charge him anything on the listing side because I really wasn't representing him. I was only representing her. Okay. And so seller reviews this thing, and he had his, they're going through a divorce attorney looks at it and goes, hey, did you sign an agreement with this guy whereby you agreed to pay him a commission? And seller's like, no. And he goes, okay, yeah, send it back to him and say you're not paying him a commission and see what happens, right? Well, I had the box check that says, buyer, you're not obligated to pay. Guess who just worked that deal for free? Okay, that wasn't my intent, was to work that deal for free. And if I would have checked the box, I could have rolled the 3% into the buyer side, right? And at least protected myself, or potentially could have, put at least 1% or 2% or whatever in there. But in that case, I worked for free because I checked the box that said buyer's not obligated to pay. Okay. So Brooke, Angela, does that at least help you understand some of the options you have at your disposal by still offering yourself some protection, but maybe not, making it look like your buyer's obligated to pay, a full 3% or 2.8% or something like that? Does that help a little bit? You guys still have questions?
It does. I've got a question for you. Because I've got a buyer client right now looking at a new build, and the new build is 2%, period, end of story. And in my ERTB, I have 2.8% and 7.1.1, and I also have 7.3.1 checked.
Yep.
So do I need to have the conversation with the buyer, like ASAP differential in what the builder's going to pay and what the buyer's obligated to pay?
Yep. So let me throw you the next curveball, Angela.
Awesome.
Okay. So you go talk to your buyer and the buyer says, hey, yeah, that's fine. I'm obligated to pay. I think you're worth your 2.8%. They're only paying 2. And so, yes, you are authorized to go request, you're instructed to go request your payment of your total success fee of 2.8% from the seller, or in this case, the builder. So you go to the builder and you say, hey, builder, I've got this exclusive right to buy whereby the buyer is obligated to pay me a full commission of 2.8%. You're only offering 2%. So we need to work another 0.8% into the commission. Obviously, the builder's not just going to say, oh, okay, yeah, we'll just pay your extra 0.8%, right? Really, the only option is increase the purchase price by 0.8% in order for the seller to, walk away with the same bottom line. Well, what do you think a builder's concern might be with doing that? You guys think of any concerns a builder might have in that situation?
Doesn't appraise.
Yep. So builders like, hey, we're already coming in with low appraisals. I'm not jacking up my purchase price to offset whatever your difference in commission is between your buyer, because we have legitimate concerns that it may not appraise. So now what do you do?
Well, you either get 2% or you go back to your buyer and say, you're going to have to pay the 0.8 at closing.
Yeah, exactly. You either go, okay, fine, I guess I'm just going to have to work for 2%, or buyer, you're going to have to bring 0.8% of the commission at closing. And guess who you're going to have to talk to about that if the buyer's getting a loan?
The lender.
The lender. Okay. So if buyer talks to the lender about that, and lender's like, yeah, hey, they don't have enough reserves if they have to pay that, or that puts them over their debt to income ratios or something else, then now you're at a decision where you either work for 2% or you force the buyer and say, buyer, I'm not going to allow you to purchase your dream home from this builder because I have an agreement signed where you agree to pay me 2.8%. What do you do?
Take the 2% and throw up all the way.
So here's what you do is you turn that person into a lifelong client, right? And you make sure that they know, hey, listen,
That's right.
We have this agreement whereby you agree to pay me 2.8%. That being said, I'm in this to protect your best interest. I am never going to stand in the way of you getting your dream home, right? I want you to know that I'm effectively forgiving 0.8% in order to facilitate this transaction. Who do you know that I can talk to today so that I can try to make up that difference? Who do you know that's looking to buy or sell real estate? And when you go to sell, I want to be your first call because you remember how hard I worked for you, and that I wasn't going to be the roadblock to keeping you from getting this home.
And you don't lead generate, sure.
Whatever, Harry, go away.
Yeah, I think that's what's key for all of us to really know and understand is, we gotta sell our worth, or we're just gonna start bending on this whole situation, and now we're not gonna be able to turn back.
Yeah.
I mean, Angela, if you think about it, you want to be a transaction broker or do you want to be a relationship broker? And what Jesse was talking about is
Right.
You're now a relationship broker. You're working with that buyer so that he stays with you for life.
Yeah.
Right.
Yeah. And so Harry, he mentioned, if you guys didn't catch it, he said, oh yeah, Jess, you don't do any lead gen. And guys, I don't do a ton of lead gen, but I have a very loyal set of past clients, right? And part of that is because I did it right the first time.
Well, that's my whole point to that.
Yeah, I would rather do it right the first time and hook them as a lifelong client.
Yep.
Instead of having to churn up new business every time because I screwed my clients when I did it the first time, and now they're never coming back to me. I mean, I think, and I haven't seen the most recent stats, but at one point NAR, they always do their annual studies, right? And if you look at the number of people who used the agent that they used the last time, it's like 12%.
Yeah, it's ridiculous.
12% of people are using the agent that they use to purchase, when they go to sell the house. Now, part of that is probably due to turnover in the industry, right?
Right.
But turnover is not 88%, right? Where the heck is that other 88% going? That's despicable, right?
Right.
And so I think if you can build those relationships, right, and really, even if you decide not to pursue them, right, help them understand the complexity of this particular section of the contract. Hey, this is what I did for you. I want you to remember me when you go to sell the house. I wasn't going to be a roadblock to you getting your dream home, whatever, right? I think you have a much better chance of working with those folks in the future than you do if you go, hey, pay up.
Yeah, so do the math on that 0.8, right?
Right.
If they were to sell down the road 2-3 years from now, you recoup that money big time.
Yep.
Right.
So,
But I think it's important to have that conversation and hold them accountable.
yeah. Oh,
I
for
think
sure.
that's where we're going to really start, just bending, and, we've got to have those conversations and let them know
Yeah.
that what we did for them is of value.
Correct. Yep. And again, you have no obligation to pursue them for that extra, whatever the deficiency is, but at least it gives you the option, right? Brooke chimed in and she said, as far as admin fees go, do you recommend writing that into other compensation? And the answer is yes. However, you got to make sure that you're checking that box. If you just check this box that says success fee will be 3.8 or 2.8 or whatever, right? And then you come down here, you don't check the box and you write $350, $450 admin fee, whatever the fee is, then you really have no right to accept that admin fee. And I'm not picking on Brooke. Brooke is an admin for a very large team, but I know I've had conversations with some of the other brokers here, and I am just personally not a big fan of admin fees. I'm not saying that they're wrong, from a legal perspective or anything like that. Absolutely, you have a right to do it, and if you can sell your value and still do it, that's perfectly okay. I just think if you really explain this contract in depth to the client, right? And especially if you're saying, hey, buyer, you are obligated to pay if the seller fails to pay, like, I think pursuing the buyer, and forcing them to pay an admin fee on top of that is just a hard pill for a buyer to swallow if they truly understand the nature of this contract, right? And so I know Angela, for instance, before she got her license, she was working with a big team who had an admin fee in it, and it wasn't Brooks, it wasn't any of the teams in this office or her office, but she was working with a large team who had an admin fee, and she didn't know and just signed it, and she ended up paying, whatever it was, a $450 admin fee. And then once she got into, once she got a real estate license and goes through the course and, understands the contract at a high level, she literally called me one day and she's like, I got screwed. This is a guy who, is highly recommended. And there was some other issues in their transaction, right? But she just felt like she got burned. And so, again, I'm not saying they're right or wrong. And if you can prove your worth, which Brooke works. Brooke, are you on Nelson team?
Yeah.
Nelson
And,
team is like
Fort Collins and
yeah, I mean, massive team. They're the top producing team at Keller Williams in any of the northern offices, I believe. So massive value on that team. And again, I'm not dogging Brooke by any means. Yeah. So they provide a ton of value to their clients, and Brooke is very good at what she does as an admin. You can't run a team that big without having an amazing admin. And so is it worth it in their case? Yes. Now, if you have a part-time assistant who is new to real estate and whatever, like, is it worth you going and asking them for an extra $500 on top of whatever your success fee is? I don't know. I think a lot of teams ask for that and are successful in getting it, but they don't actually provide the value. Okay. And that is not the case for the Nelson team. Okay.
And Jesse, I think what you're saying though is it's okay to pass that fee along to your client, but you need to communicate that to them.
Yeah. I mean, educate them, right? And I think that's
Right.
where so many brokers fall short,
Right.
is we're not truly educating our clients with respect to what they're signing. And that doesn't mean that, I mean, we've spent 3 hours up to this point on this contract, and we're not even halfway done. Like, there's not enough time in the day for you to go into this level of depth with your clients with respect to these forms. It would take you a week to explain everything to your client, right? And part of working with you as a broker is I'm leaning on you, and I trust you, right, to be the one to provide that value. And so, just again, you got to know your worth, and just asking for additional dollars here because you can is not really something that I would recommend. There are cases where the real estate commission has come down and hammered people for taking additional compensation for things that really they shouldn't have. Again, certainly on the Mike Nelson team, right there. Brooke, how many deals did you guys do last year?
208.
208. So do you think Brooke is worth the $500 a deal that she's getting, or whatever the team's getting?
300 and know that you can't charge it on a VA loan.
Yeah. So $300, like, Brooke's probably selling herself short, right? But there's a lot of people who I think just take advantage of that because they can, and they're not educating their clients in the meantime. Okay.
Jesse, is Brooke's position different than a TC then?
Brooke, I'll let you. Yeah. So
Okay.
Brooke is not a TC.
Okay.
Yeah. She's like, director of ops?
Yeah, and director of sales.
Director of sales. Okay.
I'm the one leading our 3 transaction coordinators. So I started as a TC.
Oh, okay. Thank you.
Okay.
I don't actually get the $300. It's to our team. But
Yeah. And really you can't, well, I don't know, Brooke, I don't know if Brooke's
I'm
licensed or not.
unlicensed, so I can't get a commission. Or
Yeah,
it's
so-
inactive. So
Yeah. So Brooke
Oh.
not having an active license can't earn a commission, which effectively is what that would be. So Brooke earns a salary and potentially bonus, but that $300 goes to the team, and then the team, decides what to do with it from there. Okay.
I will say we have only ever done the success fee, like actually charged the buyer an additional 0.5% of the success fee one time in our history. So
Yeah, and doing 208 deals last year, like, they've done some deals. So tells you how often it makes sense to go after the buyer for that extra, right? Again, doesn't mean that you can't, doesn't mean that you are not legally entitled to do it, but in many cases, it would be much better for you to explain your value and hook that person as a lifelong client, right? And ask them for referrals and tell them, hey, I want to be the person, which you should be doing anyway. But it just kind of drives the point home, especially when you are able to offer them, it looks like you're offering them something that really they're not, that they haven't earned effectively, is the best way to put it. Okay. And so I think you connect, on a deeper level with clients when you can sell that in the right way that really makes them understand your value. Okay.
Jesse, real quickly on that note,
Yep.
is there a training that is offered either in your office or down in the Castle Rock office that really teaches agents to sell their value to clients?
There probably is. I don't typically get into that stuff. I don't know. Brooke, do you guys teach anything as part of your team? I know Brooke
Actually,
teaches a lot with Mike.
as soon as she said that, I was like, that'd be a great class. We're
All right.
actually
Brooke, that's your next job.
right, not necessarily for the buy side, but we're actually teaching win with sellers to the Northern Colorado offices tomorrow. And we go over what our value prop is, our entire pre-listing packet, which explains the value we provide. But from a buyer perspective, that's actually a great idea. So
Yeah. Yeah, not a bad idea. So I don't know, maybe we'll put something together, but good.
Awesome.
Yeah.
I think I need to check because I wonder if there's something out there.
I think
Okay.
it's really, really important. We're in sales for Pete's sake,
Yeah.
we got to sell
Yeah.
ourselves.
Totally. Yeah. And I think, starting with that value proposition of what is the value that you provide, right? Most brokers can't tell you what their value is because they don't know how to effectively communicate it to their clients, right? And if you're going to be running a successful business, you have to be able to communicate it, right?
100%.
And you know, just I'll share a kind of funny story with you. So there was a broker in our office who had a property listed. She's no longer with Keller Williams, but anyway, had some difficulty with respect to her relationship with this seller, and the property wasn't selling. Now, this was not in, you know, the current market. This was a while ago, but the property wasn't selling, and kind of got heated between our broker and the seller. And so she asked me if I would call him and, you know, try to reason with this guy, right? And you know, effectively what it came down to was she had made some missteps, and that's okay. Everybody makes mistakes. And so, you know, she was at least trying to salvage something out of the deal. And so in the meantime, he wanted to terminate with her. There was no way that he was going to continue listing with her. And I said, hey, tell you what, let me come talk to you and see if I can represent you. And then in the meantime, I can pay a referral fee to this broker, right? And so he said, that's fine, but I want you to know I'm talking to other brokers as well. I said, okay, I'd at least appreciate a shot. Whether you choose me or not, that's up to you, right? So set up an appointment to go meet with him. Very intimidating personality type. I showed up, right? And usually when you show up to meet somebody for a listing appointment, it's a very you know, jovial, fun, right? Hey, nice to meet you. Let's take a look at your house. Tell me what you love about it, right? All this stuff. And I walk up and he goes, come on in and sit down. And so straight to the kitchen table, we sit down and he opens his little folder, and on his folder, he's got his list of 20 questions. And he starts at the very top, and, you know, he's like, tell me what you can do that, you know, these other brokers that I've talked to can't, right? And what do you think the other brokers, when you said, what are you the very best thing? What are you the best at doing? What do you think those other brokers told him?
Selling.
Yeah, I'm the very best at marketing your property and getting you the best bang for your buck, because that's what we're all taught to say, right? And so when he has, and I don't know how many other brokers he talked to, but I think it was at least 3, right? When he's talked to at least 3 people and they all come in and they all say, hey, I'm the very best person at marketing and selling your property. Well, you have at least 2 liars that he's talked to, right? They can't all be the best. You got at least 2 liars that you've talked to. And so when you're thinking about your value proposition, maybe think about something outside of simply saying, I'm the best at selling your property for the most money, right? Because that's what everybody else says too. And so if you don't have a unique value proposition, then you're just the same as everybody else. And so I talked with him for a little bit and, you know, really talked to him about the contracts and, you know, my understanding of the contracts. And, you know, certainly we touched on the sales piece as well, marketing, all these different things, right? Yeah, we talked about those. But by the end of the thing, he said, you're the only person that I've talked to who has said something other than I'm the best person to sell your property. Okay. And so I was able to get that listing. Okay. All right.
Jesse,
Well, yeah.
what did you say?
That's my unique value proposition. I want you guys to come up with your unique value proposition. Okay. But again, I mean, part of mine was talking about, I know so couple pieces. One, CMAs. CMAs are my thing, right? Angela, I know you've had my CMA class. I have my own little spreadsheet, and it's not terribly easy to understand, and it is time consuming, but I know my values and I know that I can fight an appraiser if I have to, right? I know the contracts like nobody else, okay? Certainly the marketing piece, right? I've been doing this for 13 years. I know it works. I know it doesn't work, okay? So those are things that you can consider. There's more, but you know, I want you guys to really think about what works for you. And so Brooke chatted in, you know, what they're going to do, and that's tomorrow, 11 to 1. If you want to go learn from someone is very good at what she does, and I would guess that Mike is probably going to be on that call too, or at least some other people from the team. But even if not, Brooke is amazing at what she does. Obviously, they're running a massive team where there's 208 deals a year. Like, go learn from someone who actually has a value proposition And that's what that class tomorrow is going to be for. So she chatted the link in there. Go check it out. It's worth a while. And that's part of what I love about Keller Williams too, right? Is it's not as dog eat dog out there as many of the other places that you're going to go. We're all in this together. We're all in here to help each other. There's enough sales for all of us to eat, right? So go learn from someone who's doing this at a high level. Okay.
Yeah.
And the other thing, Jesse, that some people forget, you know, a lot of times a client will see that you're going to get, you know, I'm going to use hypothetical here, $14,000. Well, in reality, you're not really getting that $14,000. So part of your value proposition has to be that doesn't always just go to you. It goes to KW, it goes to KWRI, it goes to taxes. There's a lot of things, it goes to marketing, et cetera, et cetera. So that fee becomes a lot smaller. And as you explain that and then get into what you provide, then it seems like a more realistic number. But anyway.
And if you can actually show them like, hey, here's how much I'm going to spend to market your property, right? And then say, by the time I take off this, and this, right, and pay for your marketing in the meantime, it leaves me this much to eat with my family. Okay. You know, that's something you can certainly wade into. You know, some people hesitate because like, well, your brokerage is taking too much money. Well, yeah, your brokerage is providing a lot of value, right? There's some brokerages that you can go to that don't provide any value for you. And yeah, you might get away with paying less, you know, split to them. So you got to decide, you know, what's best for you there. But, you know, certainly when you look at, you know, Keller Williams as an overall organization, and then, you know, even if you break it down to a local, right? I mean, there's massive value that some of the boutique brokerages just will never be able to provide. Okay. All right. 7.3.2. If you check that box, then the buyer is the one who will be paying your commission. And you are not entitled to receive any additional compensation bonuses or incentives or anything like that. Right. You are only, you know, entitled to pay or receive whatever you list as your success fee up there that the buyer is going to pay. And very uncommon that you would ever check that particular box. We have seen it before, and that's okay. There's nothing wrong with it. If there's a checkbox in our contract, it's an option. Okay. Okay. Any last stuff on 7.3 before we move on? Okay, let's talk about holdover. So again, a very misunderstood section of our contract. A lot of people think that, you know, hey, if you close in this number of calendar days, you're going to owe me a commission regardless, and that's not the case. So what it says is that your success fee applies to any property that is contracted for. It doesn't have to close, right? Contracted for during the listing period of this buyer listing contract or any extensions, and also applies to any property that is contracted for within however many calendar days you put here after the listing period expires. But it only applies if these things happen. So one, it has to be a property on which you, the broker, have negotiated. So if there's a new listing that comes on the market that you had never seen when your listing contract was in effect and your listing contract expired, and the next day they go see a new property to the market with a different broker, holdover period doesn't apply. You're not getting paid on the holdover period, okay? Because you didn't negotiate on that property. If you showed them the property, that's not negotiating on the property. Now, that being said, negotiating on the property does not mean that you had to have written a contract, okay? It could be, hey, I filled out some feedback, and as part of that feedback, I, you know, requested that the listing broker let us know, you know, hey, you know, would your seller come down a little bit due to the condition of the carpet, or, you know, the fact that the concrete's all cracked and broken, or, you know, whatever, right? If you can establish some kind of dialogue to, you know, show that you've negotiated on that property, then potentially you might get paid if the other provisions, you know, apply as well, but you have to be able to show that you negotiated. So phone call to the listing broker, does that work? I mean, technically yes, but how are you going to prove that? How are you going to prove that you negotiated over a phone call? I mean, unless you have a recorded line, that's difficult to do. Okay. Two, not only does it have to be one on which you negotiated, it has to be a property where you submitted its address or other description in writing to the buyer during the listing period. Okay, you cannot wait until after it expires. You have to submit that address for a property on which you negotiated during your listing period. If your listing period expires and then the next day you go, hey, buyer, here's the properties on which I negotiated, 123 Main Street, 456 Main Street, and 789 Main Street, right? You're not going to get paid on the holdover period because you didn't submit that list in writing during the listing period for properties on which you negotiated. You waited too long, you lost your opportunity. Okay, so those two things have to apply. And then there's one last provision, and it basically says, are you going to earn that commission or are you not if the buyer ends up working with another broker acting pursuant to an exclusive agreement with the buyer that was entered into during the holdover period? Okay, and so a lot of people go, well, why would you ever check the box that says, no, I will not owe that commission or that success fee if they're working with another broker? And the reason for that is, if you think about what the holdover period was really intended to do, right, that the intent there was, let's say that you have a buyer and a seller, and buyer submits an offer on the listing, and let's say it's listed at $500,000, right? And buyer submits an offer at $470,000. Okay. Seller looks at it and they go, oh, we are way too far apart. But buyer goes, okay, that's all fine and good. My exclusive right to buy expires tomorrow. And so what I'm going to do is I'm going to let it expire. And then the next day, I will go and I will resubmit my offer to the seller, knowing that now they don't have to pay a buyer's broker, in hopes that they will reduce the commission. Even though the listing broker may earn the full, percentage, they might be willing to, reduce that commission based on the fact that they're now not having to pay a buyer's broker as well. So the purpose of the holdover is to prevent a buyer and a seller from cutting a broker out of the deal, right? And effectively saving money on the commission by getting rid of one of the brokers. And so if your listing agreement expires and the buyer ends up going to sign an exclusive agreement with some other broker, and they end up going under contract with that other broker, they haven't tried to cut a broker out of the deal, right? They're not just trying to avoid paying a commission. They're just saying, you didn't get the job done. I still want to work with an agent. It's just not you. Okay. And while that may not feel good, that's at least the, reasoning why you might not check, or why you might check the box that says, no, you will not owe that success fee if you go work with another broker. And we have a broker in the Fort Collins office who every single one of his listing agreements, he checks the box that says will not, because it's like, hey, if I didn't get it done and you're going to go work with another broker, then that's fine. I didn't do my job during my listing period. I understand that, and that's okay. You can go work with another broker after mine expires. So really, in order for you to ever get paid on a holdover, first of all, you probably need to check this box. Okay. 2, it needs to be a property on which you negotiated. And 3, it needs to be a property that you submitted the description in writing to the buyer. Okay, now don't just write it on a piece of notebook paper in pencil, because what's going to happen to that? It's going to go away, right? Do it in email, send them an email, says, hey, here's the properties on which I've negotiated, here's their addresses, there's their legal descriptions. If you decide to purchase one of those properties during this, however many 30, 60, 90 days, whatever you've got here, then you're going to owe me a commission under the holdover provision. Okay. Any questions on that part? If nothing is checked here, then the holdover provision doesn't apply. Okay. Any questions on 7.4? Okay. Limitations on third-party compensation. Just don't take compensation from a third party, period. There's it's kind of interesting because Colorado has some laws that are a little bit less restrictive than RESPA. And at the end of the day, it doesn't really matter because RESPA is a federal law and RESPA would overrule anyway. And so even though Colorado may look like some things are permitted under RESPA, really third-party compensation is just not something that we should be taking regardless, unless it's actually spelled out in writing, disclosed to all parties on the settlement statements and still not in violation of RESPA, because you could have stuff that gets disclosed that's still in violation of RESPA laws, okay? So bottom line, best thing to do, just don't take any third-party compensation, from your inspectors or title companies or lenders or anybody else. Don't take envelopes full of money under the table from the buyer or, seller, right? Everything needs to be above board. Make sure it's spelled out here. Make sure it's in the settlement statements and all that stuff. You shouldn't have anything to worry about. Okay. All right. Section 9. So buyer agrees to conduct all negotiations for the property only through the broker and refer to the broker all communications received in any form from other brokers, other prospective sellers, or any other source during the term of this contract. So I was just talking to a broker yesterday, and she has an upcoming listing. And in the meantime, the sellers, so the seller is her sister, and she's the only one on title, but she's dating this other guy, right? So in the meantime, boyfriend has some friends who want to potentially purchase the property. Well, they have their own broker. And so that broker writes up a contract, submits it to our broker, right? And she presents it to her sister, the seller. Now, this was an FHA offer and it was asking for concessions and all this other stuff. And in today's market, it's probably just not in their best interest to take that offer without exposing it to the open market and seeing what they can get, right? Chances are they're probably going to get multiple offers that are not asking for any concessions, that aren't FHA, VA, whatever. And I'll talk about all that stuff here in a minute. But it's probably not the best deal that they're going to get. Now, there's nothing that says that a seller has to take the best deal, right? If this seller wants to throw a bone to her friends and sell them the house and pay, however many thousands of dollars worth of concessions and everything else, that's the seller's prerogative. They can absolutely do that. There's nothing wrong with that. But until you submit it to the open market, you never know, right? Well, in the meantime, boyfriend of the seller goes and talks directly to the buyer's agent and effectively says, hey, if you can fix these things, we'd be more likely to take your offer. So they go back and they fix it and, change some stuff, but didn't change all of this stuff. And they resubmit. And now it's like the broker is pushing because it's like, well, hold on. Boyfriend said if we change these things, then we would, be likely to put a deal together. And so now the broker's pissed and the buyers are pissed. And now there's, tension in their friendship and everything else. It's like boyfriend never should have gone and talked to the other broker, right? And we can't control him. He's not even a party to our contract, but certainly the seller should have, said, hey, knock it off. I don't want you talking to these people. Let's conduct negotiations through our broker, right? And get the best deal. And then if we open it up to the whole market and we get 20 offers and we still want to take their offer, then that's fine. There's nothing wrong with that, but let's at least see if we can get the best deal, for ourselves and know what we're potentially walking away from. Like, I'm willing to throw my friends a bone too, but if it means I got to give up $25,000, like, that's a tough pill to swallow, right? So be careful, have your buyers and sellers negotiate directly through you. I just did a deal and fortunately it worked out okay. But it was with the Fishkin team and I had the seller. Yeah, I had the sellers, Fishkins had the buyers. And lo and behold, buyer and seller stalked each other on Facebook or they looked each other up on Google or something. And then they started making these agreements that me and the Fishkin team had no idea that they were making, right? And like the buyers wanted to store a bunch of stuff in these shipping containers this home was out in none on a couple acres, and they have these shipping containers, and the buyers were like, hey, do you mind if we store some stuff there for like, 2.5 weeks prior to closing? And the seller's like, oh yeah, no problem, that's fine, that's okay. And so they let him do it. Well, we didn't know about that. And then in the meantime, the sellers are like, hey, we have too much stuff to get out by closing. So we're going to still have some stuff at the house for, a week or two after closing. And they hit up the buyer and they're like, is that cool since we're letting you store stuff here before closing? Buyer's like, oh yeah, no problem. And fortunately it worked out in this case, but I've seen disasters relating to post-closing occupancy, pre-closing occupancy, which really shouldn't be a thing, right? Like there are significant issues that buyers and sellers face in these circumstances. And if they would have run it by us, I mean, we probably could have figured something out, but it wouldn't have been a handshake deal, right? So really those communications, negotiations, they should be conducted specifically between the brokers, not between the parties, not between a party talking directly to the other broker and vice versa, right? It needs to be direct through the broker. Okay. And then this is an important piece, right? And this is one that I think often gets overlooked. Just was talking to a broker yesterday out of the Fort Collins office. She signed an exclusive right to buy and goes out, shows some property, writes an offer on this listing, didn't get accepted. And then the following weekend, she gets a text or something from the buyer that's like, hey, really sorry, but we're under contract on another property with another broker now. Well, that other broker probably didn't even, talk about this section of the contract that said, hey, are you currently a party to another agreement with another broker? Or are you not? Right. And not only that, they've added this clause in here that says, buyer further represents that you have or have not received a list of any submitted properties pursuant to a previous listing agreement. And that's where the holdover clause comes into play. Okay. If we actually cover this section with our client, then really, unless they lie to us, we should avoid any issues here. Right. And now the other broker is, on this deal is potentially looking at, issues with, okay, well, we have a right to collect a compensation. And, now the buyer's been put in a position by the second broker to potentially have to pay the second broker a commission as well. And so that second broker, by not covering these things, has now put the buyer in a position where she's liable for 2 commissions. Well, you think she's just going to, lay down and take it, the fact that she's now going to have to pay a commission to one of these brokers because the co-op broker is only going to pay one co-op commission? No, what is she going to do? Well, hopefully she turns against that second broker, right? And says, hey, you didn't advise me of this. You put me in a position where I have to pay 2 commissions. So you can either, cough up the commission or negotiate a referral agreement or something. Otherwise, I'm going to file a complaint against you for not advising me of your contract, right? So make sure you're reviewing this section with your client. You don't have to go that level of depth, but at least ask them, hey, have you signed another agreement with another broker that would require you to work directly with them? Okay. And then have you received a list of any submitted properties? Any questions there?
Question, Jesse.
Yep.
So
Okay.
I have an exclusive right to buy for a residential property, and they have an exclusive, they haven't signed it yet, but they're looking for commercial properties. So we're looking for 2 different types of properties. So we're good, correct? As long as it's described up above and whatever
Yep.
that section is.
As long as it is clear that those are 2 separate deals, right? And you're not overstepping any boundaries there, then yes, that is okay. The other thing that's okay is you can sign a listing agreement, right? And even though I say listing agreement, a buyer listing agreement is still a listing agreement. And that's what the exclusive right to buy is. It is specifically called a buyer listing contract, right? Tells you right here, it's a buyer listing contract. So whether it's buyer or seller, doesn't matter. You can still have a listing contract, even if they have a listing contract, with another broker who's helping them with the same one. You can, even if this is still in force, you can sign yours today that becomes effective upon the expiration of contract number 1. Now, you should never have a copy of the other broker's exclusive right to buy, right? You need to either ask the buyer or you need to ask the broker, hey, when does your contract expire? And if a broker asks you, you are supposed to tell them, and that gets a little bit tricky. You shouldn't just go around calling brokers saying, hey, tell me when your listing contract expires, or tell me when your exclusive right to buy expires. Really, the reason that rule exists, that we have to tell other brokers when it expires, is because if that buyer approached me and said, hey, my first broker's not cutting it, I want to work with you, but I have this agreement in place, I, as the second broker, should never interpret their exclusive right to buy because it wasn't written by me. So either the buyer needs to do it or the broker needs to do it so that I can fill out my contract effectively, knowing that I've had the discussion with this broker, or that the buyer or seller, on the other side, the buyer or the seller is comfortable with understanding when their contract expires. And if they tell me that, then I'm going off of their word, right? And then if they have some other obligations to the other broker or whatever, I don't care. I didn't advise them on their contract. And the reason it's important that we not advise on another broker's contract, first of all, we have no authority to do that. That's the unauthorized practice of law. And secondly, is you never really know whether they've provided you with all of the forms that they signed. What if they send you a copy of one that shows it's expired, but they forgot that they signed another one? Okay. Or we had a legitimate, full on get attorneys involved, demand letters, all this other stuff in the Fort Collins office with a broker who he did just that. He looked at a copy of the other brokers. It was on the sell side, the exclusive right to sell. And he told the sellers, like, oh yeah, yours expired. You have no other obligations, to that broker under your contract. And what he didn't know is that one of the two sellers had actually signed an amend extend, extending the term of the listing agreement. Well, is that valid or is it not? I mean, technically that extension never got fully executed, right? And the broker realized that. They never actually put it back in the contract, put it back in the MLS. But still, we weren't aware that there was we didn't even know that there was an amend extend out there extending it. What would have happened if the other seller would have signed it, right? We didn't know because the seller didn't give us that copy. They did give us another one. And in the meantime, our broker looked at it and said, oh yeah, you have no other obligations under the terms of this contract. Well, that in and of itself is the unauthorized practice of law. And so the other broker threatened, hey, you're either going to cough up half of the commission and give it to me, or we're going to file a complaint to the real estate commission against you and to the bar for the unauthorized practice of law. So don't ever take contracts, don't ever take, exclusive right to buy, exclusive right to sell that was listed by somebody other, or that was written by somebody other than you. Okay. Of course, the exception is if you have a listing and the buyer sends you an offer, the buyer's broker sends you an offer. Of course, you have the ability to interpret that. That's fine. Okay. Any questions on that piece? Okay, let's talk about the rights of the parties to cancel, and then we'll call it quits for today. So 10.1 is the right that a buyer would have to cancel the contract. So again, if we were to go back up to section 1, what it says is that this is an irrevocable contract, meaning it can't be revoked. It is not just one party saying, hey, I don't want to do this, right? We can certainly terminate it with mutual agreement at any time, but it is a bilateral contract, not a unilateral contract. And so, however, the buyer has certain rights to cancel regardless, okay? But only if these are met. So if the broker defaults under this contract, the buyer can cancel the buyer listing contract, including any rights of the brokerage firm to earn a commission or compensation, yada, yada, whatever. Okay. And then it goes on to say examples of broker breach include, but are not limited to. So it gives us a list of some things, but this isn't meant to be all inclusive. Okay. So one is if you abandon the buyer. Well, where is abandonment defined in this exclusive right to buy?
It's not.
It's not. So how do you know whether you've abandoned the buyer or
Buyer's perception.
not? Yeah, I mean, go argue it to a judge, right? It's really the judge's perception, but probably it's going to be heavily weighted towards the buyer. So unless you have documentation showing, hey, no, I didn't abandon the buyer, right? Like, here, look, I checked in with them every couple days. Here's my phone log. Here's all the emails that I have with them. I showed them properties on these days, right? Document it, and then that will hopefully help you fight against a buyer who claims that you abandoned them, right? Because it's not defined anywhere. You'll see it's lowercase. That means it's not a defined term, okay? So abandonment, if you fail to fulfill all of your material obligations, which we'll come back to, okay? And I want you to keep in mind, material obligations are different than your material uniform duties if you are a transaction broker, or your additional duties of a buyer's agent if that agency box is checked at the top. Okay, so this deals with duties in section 5. Our uniform duties, we have whether we are a transaction broker or a buyer's agent, right? So if we violate or fail to fulfill one of our uniform duties, then buyer would have a right to terminate. If we're a buyer's agent and we fail to fulfill one of those 3 additional duties in section 6, they could terminate. Well, then what is a material obligation? Well, a material obligation is some other obligation that is written somewhere else into the contract. And so typically 12.1 would be a section where you might find some material obligations if you're going to perform some additional tasks that you write in here. You might also find it down in additional provisions, right? You might attach something to the contract. Those things that get written into this contract elsewhere, those would be examples of material obligations of the broker. Now, not everything that you write into here is a material obligation, but whether it's material to the transaction or not, again, that is not defined. Material is not defined. And so is it material to your contract or is it not? I don't know. Go argue it in front of a judge. But what you do, if you start writing a bunch of extra stuff in here in 12.1 or down into additional provisions or anywhere else, right, you're just increasing the possibility that a buyer could have a right to terminate this contract based on your failure to fulfill one of your material obligations. Okay. The right of the broker to cancel. So we don't have nearly as much wiggle room. We can cancel listing contracts upon written notice to buyer if buyer fails to reasonably cooperate with the broker or if the buyer defaults under the listing contract. Well, where is a buyer? I mean, what does a buyer default include? They didn't even give us a list of 1 or 2 or 3 things other than to say, hey, if the buyer fails to reasonably cooperate. Where is that defined? It's not. So really, we don't have a good way to wiggle out of this contract. And that's important, particularly when we talk about the commissions, right? If you said, hey, buyer, you're not obligated to pay, and then you go, well, I'm not going to, perform brokerage services for you because I'm not getting paid in conjunction with this transaction. Well, if the buyer's okay with that, you can terminate it at any time. But if they're not, they say, well, I don't really care whether you're earning a commission. You agreed to do brokerage duties and you agreed that I wasn't obligated to pay. So perform your brokerage duties and you're working for free. Okay. So any questions on that piece? Yeah, we'll cut it off there. Any questions on anything we talked about today or anything else in general? Nothing. Okay.
Jesse?
Yeah, you bet. We'll see you guys. Don't forget on Friday to this week. I think it's 12 to 2. We have the additional provisions, competitive market class that I again, it's kind of a hodgepodge of 3 different classes that I'll be teaching. I know some of the people in Castle Rock were probably on that a week or 2 ago when I did it. There's not going to be anything new from that time, but it will kind of be a mishmash of 3 different classes that I have taught. And the link to that class is the same link that you use for for this class, the contracts class. So you can just find that link. I'll repost it in both pages so that everybody can see it, but same exact link for this class. So that's Friday. Don't forget Brooks class tomorrow. That's from 11 to 1. So lots of value for you guys. And I know a lot of you guys are in coaching. I don't know what the coaching, or what may or may not overlap with coaching.
We have 9 to 11 tomorrow, so that should be good. And we don't have anything on Friday, so it's perfect.
Cool. Yeah. So didn't want to step on coaching's toes there, but I think that class tomorrow will be valuable. They're the top producing team for all of the northern offices. And I think by volume, they probably beat out anyone in the Castle Rock office too. So good class to go to if you guys can squeeze it in. Otherwise, I will plan on next Tuesday from 9 to 11, and we'll pick it up where we left off. So,
Hey, Jesse, are you
Yeah.
recording Fridays 12 to 2 by any chance?
yeah, so we didn't record the last one because we ran that through Colorado Springs training, and we don't have access to their recordings. But the one on this Friday will be recorded. I don't know that the one tomorrow will be recorded. So if you guys want that, copy that, and you'll have to go to that one. But this Friday's will be recorded.
Awesome. Thank
Okay.
you.
Thank you.
All
I'll
right.
get that out to everybody.
Okay. Sounds good. Thanks, Harry.
Thanks.
Okay,
Have
we'll
a
see
good
you
one.
guys. All right. We'll see you.